Thank you very much. Your Eminence, ladies and gentlemen, I feel privileged to address you here and thank Monsignor Sorondo and President Archer for creating this opportunity. I have been an independent rapporteur, national rapporteur in trafficking now for 10 years. But before then, I was at first a public prosecutor and then a judge for many, many years. Thank you. The red one. And as a matter of fact, I've been part of the judicial system since, well, I think for over 40 years. I think that is, for me, at the start of my rapporteurship, I was still a part-time judge. And I think that was, for me, the reason that I have very much looked at what judges are doing in this field ever since I was a national rapporteur. From the start, I have scrutinized the role of judges in the fight against human trafficking. I've looked at their rulings, sentencing, and at overall on their involvement in the fight against trafficking in human beings. I have conducted 2 extensive research projects into the jurisprudence on trafficking, which in the end resulted in a specialization and specific training of judges in the Netherlands on the subject of trafficking for judges in the criminal court. Judges are important and always have been. In bygone years, justice was administered on the top of a mountain, far from the banality of everyday life, somewhere between heaven and earth. Judges' sacred and autonomous status offered a guarantee against external powers, whether they were other citizens or the state. But the idea of a judge at a distance is a thing of the past, or it should be. Today we talk about the important role of judges in tackling human trafficking. The diversity and dynamics of the phenomenon mean that judges are being challenged more than ever before to be aware of what's going on around them. Alongside the image of the autonomous judge, I want to set the profile of the judge who has a situational awareness, a judge who participates. I think this is the one I want. A judge who participates and feels part of the greater whole. Because at the end of the day, no matter how much a country invests in the fight against trafficking, if the case ends in an acquittal, it has all been in vain and victims are left empty-handed. I would very much like to see this sense of urgency also within the judiciary, of course, all within the rule of law. And what do I mean with situational awareness? First of all, I'm thinking of the way in which judges relate to the phenomenon of human trafficking, which is a complex issue that occurs in highly varied forms, but a phenomenon that is also changing over time and one that requires an equally dynamic response. And I'm talking here about how important it is for judges to interact with society and the different forms of human trafficking that keep popping up. Equally important is for judges to interact well with their fellow judges in other legal fields. A just treatment of victims in legal proceedings requires an approach that extends beyond single areas of law, a holistic approach. No silo effect, but an all-embracing approach in which the expertise from the various legal domains are studied in conjunction and not separately. And thirdly, judges with situational awareness take into account their role as being part of the world, part of an international law and European law, and the influence of these on the work they do. These judges are conscious of their important role in expanding that law with the experiences they have gained and are gaining at a national level. I'm making a distinction, therefore, between 3 situational factors that judges in human trafficking cases need to relate to. Allow me to go through these 3 with you. First of all, social reality. Human trafficking is no static legal fact, but occurs in reality, in society, in a multiplicity of forms. Constant factors are exploitation. Human trafficking aims at financial gain, coerced by violence or much more subtle forms of coercion. Human trafficking seeks to profit at someone else's expense, someone who is often in a highly vulnerable position in relation to the human trafficking. Although everyone has an idea of what the term human trafficking entails, it is the legislator's job to encapsulate the social reality that it represents in abstract terms. And then it is a challenge for judges to reconcile these abstractions with the facts that are manifest in a concrete case. Reality used to be fairly clear-cut. Up until 2005, only sexual exploitation was in the Netherlands a criminal offense, in many countries also, and we could well imagine the suffering that lay behind it. When labor exploitation became a crime, this was already much more difficult. But recently, the courts are finding themselves increasingly confronted with cases of what we call criminal exploitation. Exploitation which involves victims being forced to commit criminal offenses, shoplifting, drug smuggling, cannabis harvesting, all services which people can be forced into. But how are we to spot human trafficking behind a 16-year-old shoplifter? There's nothing about the shoplifting that betrays signs of human trafficking. In the Netherlands, Romanu and Janu, two Romanian boys, were taken by their uncle to Wassenaar, a well-heeled village close to The Hague. It happened more frequently, and every time the instruction of the uncle to his nephews was, "Get everything out of the houses for me." In Wassenaar, the uncle and the nephews were caught. The nephews were sentenced to 6 weeks in jail and sat out their sentence. The uncle was sentenced much later because it was realized that he was not only guilty of theft, but also of human trafficking. And here we see how criminal exploitation poses challenges to the criminal justice system. The nephews in our case are not just perpetrators, but also victims. And how do we deal with this duality? And what do you do as a judge if you are confronted with a victim who is also a perpetrator? One would hope that from the outset in such cases, the public prosecutor would decide that prosecution is inappropriate, but otherwise judges have a vital role to play here. And judges need to respond to the new challenges arising from changes in social reality, in our case, the new reality of criminal exploitation. The judge's ability to be constantly gauging a changing reality is tested here to the full. It is a crucial skill because human traffickers are cunning and they switch to tactics incessantly, especially now in the face of the influx of refugees. The fate of refugees is worrying, not simply from a human perspective, but also from a human trafficking point of view. It is crucial for judges to relate to society, but equally so, judges must be aware of the situation of their colleagues in other legal domains. Human trafficking has too many faces to be tackled in a straightforward way by a repressive approach derived primarily from criminal law. Administrative law, immigration legislation, and labor law play a vital role. A view that looks beyond individual legal domains is needed. To illustrate my point, let me tell you the tale of Santosh, a 13-year-old Indian girl who came to the Netherlands in 1999 to work in the household of a well-to-do Indian family. For 7 years, Santosh had to work excessively long hours and had to be available at any given moment. She was exploited for years as a domestic slave, but besides her exploiters, Santosh was also convicted. What was the story? During the time of her own exploitation, Santosh was instructed by her exploiters to maltreat the baby of 2 other housekeepers, who, according to the exploiters, the traffickers, was bewitched by evil spirits. After a gruesome scene, the baby died, and Santosh, despite the fact that everything had happened in a situation of human trafficking where she was the victim, was sentenced to 5 years in prison. The conviction of Santosh had major repercussions because, as the first domino to fall, it proved to have an immense impact on the outcome of other proceedings in other legal domains. Thus, the conviction was the immediate ground for Santosh being declared an undesirable alien. The conviction served to ensure that Santosh was not granted the protection which all human trafficking victims are entitled to by virtue of immigration legislation. She had thus no right to temporary residence and protection. And we see here how much influence a decision taken in one legal domain has on the substance of a decision in another legal domain. The decision took no account of the lamentable circumstances that Santosh found herself in as the victim of human trafficking. And then I've not even mentioned the discrepancy between criminal law and labor law. Exploitation is defined in the Netherlands by Dutch standards, but the labor judge decided in the case of Santosh that the work had been performed in an entirely Indian context, and that therefore Indian labor law was applicable. The calculation was easily made. For working an 80-hour week, unpaid, for a period of 2 years, Santosh was entitled to back pay of 2,020 euro. What the case of Santosh demonstrates is that the protection of victims is a challenge thwarted by the subdivision into legal domains that we ourselves have created. This case is an argument like no other for judges to look beyond their own legal field. Interaction between criminal, administrative, immigration, and labor law is indispensable for the protection of human trafficking victims. And that brings me to the third and last situational factor shaped by the international dimension. And I mean by this not just the impact of international and European law, but also the importance of the knowledge of and interaction with fellow judges in other countries. The internationalization and European, well, I'll just say globalization of law is accelerating fast. In cases of human trafficking, international and European law is leading. The definition of human trafficking in the United Nations Palermo Protocol dates from 2000 and provided an international definition for the first time. And much national legislation has been geared to this definition right up to the present day. And the definition was adopted virtually intact in the Council of Europe Convention on Action Against Trafficking in Human Beings, while the European Court of Human Rights in its judgments has included far-reaching positive obligations for states with regard to tackling human rights and protecting victims. Judges are, on the whole, expected to operate within this international judicial reality and to adjudicate in the spirit of the documents I've just mentioned. The relationship of judges to international law is absolutely one of interaction. International and European law only take shape through their transposition into law by the national courts. And despite the creation of a uniform worldwide definition, the human trafficking provisions are interpreted in diverse ways in different states. And my view is that this is attributable, above all, to the open formulation of the definition. The different parts still allow a lot of scope for interpretation by the courts. The international definition, for instance, sees the abuse of someone's vulnerable position as being a form of coercion. But what is a vulnerable position? As and when does someone abuse it? National courts are the key in answering these questions, and this is why it's absolutely crucial for the judges from different states to keep in touch with each other, as we're doing today. I remember from my time as a juvenile court judge and as Secretary General of the International Association of Youth and Family Judges and Magistrates that such contacts were by no means self-evident. It was through this association that I met Luigi Fadiga, president of the Family Court of Appeal here in Rome, who came in very handy in a case of child abduction involving an Italian father and a Dutch mother. My court couldn't imagine why I would want to email my Italian colleague to ask about the application of family law in Italy. But what he sent me, though, was a detailed overview of the most recent case law, exactly what I needed to handle the matter properly. This was 15 years ago. I was, at first, somewhat ridiculed about my Cher Luigi email. Now there is a working connection by family judges on cases concerning child abduction, as stated in the Hague Convention. So things do change, and they must. An ongoing interaction exists between international and European law and the national courts, underlining for me how important it is for judges from different countries to share their experiences much more than they do at present. I made a strong case for this in an article I published this month in the Anti-Trafficking Review, and I'm glad that the United Nations is currently working on a database of translated human trafficking cases. And I'm also happy with the recent development of a European case law database by the European Commission. And that's how we will be able to exchange the solutions we have found at a national level. Ladies and gentlemen, I've said most of what I wanted to say. I've demonstrated how vital it is for judges to interact with their surroundings given the complexity of the issues confronting judges in human trafficking cases. Judges need to come down from the mountain and mingle with the crowds. I spoke recently to a captain of a Boeing 747, and we got talking about the special skills that pilots need. It's absolutely imperative for them, sometimes under stressful conditions and in a setting full of stimuli, to combine all their information into a usable whole and use it as a basis for appropriate action. And that skill is called situational awareness. And it was then that it struck me that judges dealing with human trafficking need the same skill as pilots. Judges, like pilots, have to have command of the priority information they need to take the right decision in a demanding situation. In interaction with the ground and the air, with society, other legal domains, and international counterparts. In an endeavor to fly towards freedom, the freedom that is still not a reality for the millions of human trafficking victims, but must remain in our sights on the horizon. Thank you very much for listening.
Thank you very much.